business owners. So the background check reveals that your star new hire has a criminal record. Can you reject the candidate? Should you reject them? You know what time it is. It's time for the Friday Legal Fix. Here's the deal. Everyone who's ever gotten an offer letter knows that there's a little sentence or two in there that says your position is contingent upon successfully passing the background check. For most of us, it's a mere formality. However, every once in a while, you'll find someone who has some things that has happened in the past that may have resulted in a conviction. As the employer, what are you supposed to do? First off, you want to make sure that you're not asking for that background check prematurely. Many states like Maryland, Virginia, Pennsylvania require that you wait until after the first interview or conditional offer is made before asking about criminal history. So check your state's specific rules. Second, if you want to steer clear of claims that you're discriminating against anyone, you'll need to conduct an individualized assessment of the conviction. Now, I know my HR peeps like it quick and dirty, and they want to use the rubric to cut through the noise. But just like the ADA, you really need to take a look at the following factors before making a final call. What is the nature and the gravity of the offense? Meaning, what happened and how bad was it? How much time has passed since the offense happened or the completion of the sentence? And lastly, what is the nature of the job being sought? For example, a 10-year-old DUI conviction or for a remote IT position? Probably not relevant. But a 2-year-old conviction for writing bad checks when you're applying for an accounting or finance position? Likely relevant. Under federal law, before making any final decision, you have to provide the new hire with written notice that you're considering adverse action. In other words, that you're withdrawing the offer. So you have to give them a copy of the background check report and their federal rights summary. Skip this, and that's a federal violation. However, finding a criminal record doesn't automatically disqualify someone. And you know what? Nor should it. Blanket policies could also get you sued for workplace discrimination. After the notice, you have to give them a chance to explain any discrepancies or their rehabilitation efforts. You got to document this conversation. It's your evidence of a fair process. Here's a critical mistake to avoid. Never automatically disqualify anyone. The EEOC considers this discriminatory because it disproportionately impacts protected groups. Each case needs an individual review. Again, document your decision-making process thoroughly. If challenged, you need proof that you considered job relevance, not just the existence of a record. Last thing, human to human. Carefully consider the person's work history since the conviction. Have they successfully worked at other places since the conviction without issue? If so, why not allow this person the opportunity to continue? Under the right circumstances, most folks deserve a break to turn their lives around. You want more tips about how to navigate these sticky employer issues? Check out topemployermistakes.com. This is Aisha from Cedric Andrews, your small business legal guide. See you next time.